Succession does not respect anybody. Upon death, issues can arise. We appeal families to settle this. We are also saying, if you delay for so long to make a claim of succession, you cannot be given a time to deal with it. Welcome to Court Helicopter Explainer. We are still dealing with the question of death and succession. Today, we are looking at the king of the Maasai, the man who stood and reigned the Maasai community. His word was law. He is none other than the late William Rongora Ntimama, alias William Ntimama. This is another colossus, another minister in Moi's government. This was the case that appeared in succession in Narok, succession course number 12 of 2017. Justice C.M. Kariuki J. delivered a judgment on July 31st, 2025. What is the introduction? Before the court is summons dated 13th August 2024, brought under section all these issues, seeking reasonable provision from the estate of the late William Rongora Ntimama, alias William Ntimama, the deceased. The first and second applicants, that is Sharon Lanoi Siomit and Shakei Dana Malkia Sekentia Liomit. The first and second applicants are the biological daughters of the late Francis Siomit Ntimama, who was a son of the minister. These are the grandchildren of Ntimama. The third applicant is the widow of the said Francis Siomit Ntimama, Francis' wife, and her two children have gone to court. They assert their claim under the principle of representation, stating that as direct dependents of the deceased son, they are entitled to reasonable provision from the estate. The applicants further seek an order varying the deceased will dated 25th July 2015 to the extent necessary to provide for them. They argue that the will did not make any provisions for them despite their dependency, and that in light of the circumstances under Section 28 of the Law of Succession Act, it would be just and equitable for the court to make provision in their favor. They sued Commissioner Samson Omwansa Ombati. He is now the commissioner of the JSC, my senior wakili, who was appointed as an executor, and also Sanaipei Deborah Ntimama as a beneficiary. Let us put this to perspective. Ntimama died. There was a will. Before he died, his son Francis had died. So the will did not provide for the wife of his son and the children. And many a time, at the time your father dies, and this is very common, by the time your father died, one of your siblings had died. But he has a wife and he has children. The chiefs write letters, only the children who are alive. That one who has died, his wife is not put there. Sometimes the one who has died, the remaining siblings chase away the wife. This is very common in Kenya today and in Africa today. That young widow goes away with children to her mother's place. So she comes back, a will had been written. So she comes back with the children, saying we need to be provided because we are grandchildren of the late Ntimama. What did the standing say of dependency? The applicants claim, that's paragraph 46, the applicants claim standing through the principle of representation under section 41, asserting they are the widow and the daughters of the predeceased son who had died. And they rely on the re-estate of Luka Mudole, or case number 2020, and the re-estate of Phyllis Mudodi of 2019, where courts held that grandchildren can inherit by representation where their parent was a child of the deceased. Courts have held the grandchildren have a right to inherit if their father who died was entitled to inherit. However, Mr. Mwanza Council disputes both paternity and dependency. Omwanza said, these children, the woman left here without children, she must have gotten those children elsewhere. He argues that the deceased never acknowledged Francis Yomit as his son, nor the applicant as his dependent. He emphasized that biological relationship alone does not establish. What did the court find? The court finds that while the applicant asserts a biological relationship to the deceased, there is no sufficient documentary or sworn evidence, such as a birth certificate. They failed to produce a birth certificate, marriage certificate, or an acknowledgement of records was presented to prove such lineage. And without proof of dependence or familial recognition, they fall outside the statutory definition of Section 29 of the Act. They lost. The final orders are that upon careful analysis of the pleadings, affidavits and submissions of both parties, and in light of the authority cited, the court finds that the applicants have not proven dependency or familial relationship within the meaning of Section 29. The will of the deceased was lawfully executed, probated, and fully implemented with no evidence of impropriety. The applicant's summons is term barred, lacking justification for the prolonged delay. The interlocutory application is unsustainable as no prima facie case or imminent harm has been established, and therefore no legal or equitable basis to vary the deceased will. Justice Charles Kariuki on 31st day of July 2025. This brings out another fundamental case that is going on. The case of the former president of the Republic of Kenya, His Excellency President Emilio Mwai Kibaki. The case is still going on about his succession. We cannot discuss much about the case of Mwai Kibaki. But within Mwai Kibaki, the issues that are there is that there is somebody claiming to be a wife. Mary Wamboi is one of the people claiming she's a wife. She's entitled to that property. Lucy Kibaki and her children are tussling over. Out of that, there are people, there is somebody claiming he is Kibaki's son. He has put photos all over saying he is Kibaki's son. And the question that was determined in this matter that we have just dealt with of Ntimama, is he a biological child? Has DNA proved him to be a biological child? Will he produce evidence that Mwai Kibaki was assisting him and was providing for him? I wouldn't talk much about it. We are waiting for the decision of the succession matter of President Mwai Emilio Kibaki. What are the lessons in this matter? The lessons in this matter is that succession does not respect anybody. Upon death, issues can arise. We appeal families to settle this matter. We are also saying, if you delay for so long to make a claim of succession, you cannot be given a time to deal with it. Wakili Dan Senomari, bringing it to you as it is always from Court Helicopter News.